Hey everyone, welcome. It's Dave Brannen here. We're ready for another week of Ask a Lawyer Live. I am a lawyer at Resolute Employment and Disability Lawyers, and I'm here to answer your questions. Today, we're going to focus on CPP disability and specifically the reconsideration appeal aspect of a frog in my throat here already. The reconsideration aspect of a CPP disability claim. I'm going to take you through that today, answer your questions. Then we'll follow it by a Q&A afterwards, where I'll answer any questions you have. I got a lot of time this afternoon, so we can answer all the questions people have. Thanks for joining me again. I see we've got some people coming on in. Just as some housekeeping, if you want to ask questions, if you're new here, just put your question in the chat and in the YouTube chat. Just put a Q in front of it. Helps me out. If you have comments, you're free to put those in there. And I'll post your questions up on the screen and answer them as we get into that part. Alrighty, so let's do this. As always, I am going to restart again because I'm going to try to clip this video out, and we'll take it from there. Make sure I have everything here. All right. All right, folks, you ready? Let's take it from the top. All right, let me do it. Let me get all geared up here, get my energy going. Let's take it from the top. 5, 4, 3, 2, 1. Hello, welcome. Today we're going to be talking about reconsideration appeals for CPP disability. I'm going to take you through the process from when you get your initial denial letter to how you do the CPP reconsideration. I'll give you some tips and tricks. Hopefully that will help you get your claim approved. Let's dive on in. And I forgot to mention, I'm David Brannen, disability lawyer here at Resolute Employment and Disability Lawyers. I have done a lot of CPP reconsiderations in my day, hundreds of them, maybe thousands. I don't know if I'm to 1,000 yet, but I've done hundreds for sure. Let's start out with a overview of CPP disability. So this is a benefit. A CPP disability is a benefit meant for people with a severe and prolonged disability that prevents them from regularly working at any type of employment. You apply for CPP disability using an application process, and if that application is denied, then your next step is to do a reconsideration appeal. What that means is you're asking Service Canada to reconsider their decision to deny your appeal. Now, this gives you a second chance to get your application approved, and a certain percentage of people do get approved at this stage, and we'll take you through that. Now, you have 90 days. So when you get the initial denial, when you get your first denial letter from Service Canada, you have 90 days to request your reconsideration. I'm going to put the emphasis there on request, because you do not have to have the full reconsideration done in 90 days. You just have to request it in 90 days. That is extremely important. Now, this is a firm deadline. So if you don't request the appeal within the 90 days in the proper way, then you will be considered to have missed your appeal. And there is some latitude for Service Canada to forgive you and to allow you to go forward, but they do not allow that easily. And also, you have to have a good excuse for missing the deadline, which a lot of people don't have, other than just procrastination and things. So unless you have a good reason, most often Service Canada is going to deny your request to have an extension. What I would recommend is, if you think you've missed the deadline, I would seek advice from a lawyer or an experienced advocate to find out how you should best present your reasons for missing the deadline to make it more likely that it would be accepted. Okay, so let's just go through the process, how it works. You need to, once you get your denial letter, and we're going to look at these denial letters at the end here, a sample one. You get your denial letter, and you then have 90 days to request in writing a reconsideration. So what I recommend is you fill out the reconsideration request form, which I'm going to show you here during the presentation. and get that sent in as soon as possible. You don't have to wait. I would request it. You want to request the reconsideration immediately. And what you do is you indicate that you're going to send more documents. And for them to not make their decision right away, you're going to send more documents. But you should just request the appeal immediately. Most people think they have to wait and do it all at once, and they will then delay because they're trying to get records. They're trying to figure out what to do. And in the meantime, they haven't requested it, and then you're more likely to just miss the deadline to request it. Whereas if you just request it right off the bat, then now you've met the 90-day deadline to request it, and they'll give you some time to get more records in. They're not going to wait forever, but you at least will not be late for requesting the reconsideration. And they could deny the request, they could deny the reconsideration, but at least you'd be allowed to move on to the next phase. So let me just get back to my list here. So first of all, you're going to request in writing the reconsideration. I suggest just using their form rather than doing a written letter, but technically you can do both. You want to add any new medical records or reports. Usually you won't be successful if you're not adding anything new to the reconsideration. So you would add the new record or report. Again, you don't have to do this at the same time of the request. In fact, I recommend you just make the request and then send in the new records within, in a few weeks, whenever you get them. A different reviewer at Service Canada will do the reconsideration. It is not done by the same person. So a new person will review it. And then you're going to get a decision in writing from that new person. Usually once you've gotten all your information in, they get a decision out roughly in 30 days or so. So you will just have to wait to get that decision. And we're going to look at one of these, a reconsideration decision as well, once we get to the end of the presentation here. Let's consider some key documents that you want to submit. So first of all, number one, I recommend you use the official reconsideration form provided by Service Canada. That way you're not missing any critical information necessary for you to make a proper request for reconsideration. You will also want to include, as I mentioned just a minute ago, updated medical evidence. That could be any new information that you've gathered or any information that wasn't previously submitted. It might be your doctor responding to make further clarifications, something. You have to put something new in order to have some chance of success here. And okay, finally, yeah, so support letters from the doctor. That's pretty much it. You want to connect the dots between your disability and your inability to work. So it's very important to make the connection between your physical or mental limitations and restrictions and how those relate to your inability to perform the duties of any type of employment. All right, so common reasons for denial. The reasons on these letters are very common because Service Canada now just uses a standard letter that they just give to everyone. So basically everyone gets the same reasons for denial. They've stopped customizing. They used to get kind of a customized reasons. They stopped doing that. I don't know if it's just to make things, I assume it's to make things move more quickly for them. So if you're being denied, you're basically going to get the same reasons as everybody else. There are some variations, but they're all part of the same templates that Service Canada uses now. But generally speaking, if you're looking for, what are the real reasons you were denied? It's going to be one of a few things here. Number one, it will be some statement that you have some problems, but you don't meet the criteria for either a severe disability or a prolonged disability or both. So that they will make a general statement like that. They will say, another reason they might deny it is they might say that you are still working and therefore indicate that you are not having a severe and prolonged disability. So if you're still working, that can be a reason for denial. That you can still appeal. You might be able to still win even though you're working, but they will, if they see you working, that's almost an automatic denial. They can say that you didn't explain how your disability affects your day-to-day life or your work, that there's not enough information there on, like, usually they're not going to put it that way, but that could be a reason that you're denied, is that you didn't really make a good link and they're not able to make the link themselves between how your symptoms prevent you from doing not just your own job, but any job out there. Finally, one of the reasons you can be denied is you just don't have enough contributions. So what they'll say is, yes, we see you have a disability, but unfortunately your disability onset was after the last time that you had enough contributions. This is a more technical thing that I won't really get into here, but CPP disability is not enough to prove you're disabled. You have to prove your disability onset happened when you still were covered for CPP disability. CPP disability coverage will end. Tip for most people, if you've been a constant contributor, it will end about 2 years after you stop working. So if you stop working for reasons other than disability and you're out of the workforce for more than 2 years, then you're going to have a real problem to get CPP approved, because your disability will happen after the last time you had coverage for CPP disability. Okay, so it doesn't matter that you've been out of the workforce for a while. Like, we've represented people out of the workforce for 10 years. As long as the reason you went out of the workforce was disability and the disability has been continuous, then that's that kind of case you can make. It's when you were out of the workforce for other reasons and then became disabled that you can run into a lot of problems. So some general tips on improving your chances. Number one, it's not enough just to describe your diagnosis. You have to make a link between how your condition prevents you from doing specific job duties. This is one of the hardest things for people to do, but it is one of the most important aspects of winning this type of case. There has to be a link. Now, as long as you're providing them with enough medical information, the medical adjudicators are trained to look to see if those types of links are there. But again, they can't do that if you're not giving enough medical information. So for example, we always recommend that you give your complete family doctor's file as part of your application, going back as far as needed in the past to give an accurate picture to show how your medical condition gradually worsened over time and got to the point where you had to finally go off on disability. Now, the other thing is, you can ask your doctor to comment directly on whether you're capable of working. Some doctors won't really want to go there. Others will. What you don't want to have happen is just your doctor to say things like, my patient has a severe and prolonged disability. That's not helpful at all. So don't try to encourage your doctor to say it. There's no magic words, and that won't help get your case approved. What you want the doctor to say is that my person has these types of impairments and restrictions because of their medical condition and symptoms, and that would prevent them from either sitting long enough to do a sedentary job or standing long enough or concentrating. There needs to be like a direct link, and sometimes your doctor can help with that type of description, but some doctors aren't willing to kind of go with that kind of detail. All right. It's worth saying that you don't use emotional language or kind of pleading to them to say, look, I'm desperate. They're used to seeing that, but it isn't effective. They really are more focused on, do you have medical records that show that you have a severe and prolonged disability? That is going to be the key. They're also going to be fixated on whether you have followed medical advice. So that is another thing. If you haven't, that's going to be a big problem. The other thing they're going to look for is whether you made attempts to stay in the workforce, or did you just stop work at the first sign of trouble? So this is the kind of information and evidence you want to be able to get to them, and that's what they're looking for. All right. So when should you get legal help? You don't always need to get a lawyer, and I don't recommend that everybody get a lawyer. In fact, there's also other non-lawyers out there who help with disability claims who are very good as well. So you want to find the right person to work with, someone you trust. And like I said, some people who help, like us, will charge a fee. There are some services out there that will do it at no charge, or you can just do it yourself. And the reason when you would want to get outside help from a lawyer or an advocate is when you are incapable of really managing the process of applying. And that is that's a reality for some people, that you've already had denials in the past. Maybe this is your second time around trying to apply for CPP disability and you're running into problems, or you've did a good effort to get your application in and now it got denied. So maybe it does make sense to get another person, an outsider, to look and see, okay, what do we have to do to push this over the top to get it approved? And another time to get help is if you're really dealing with a complex situation, or you're having difficulties with your doctor getting the right kind of evidence or information, that's another reason when it can make sense to get help. Now, there are the type of help you can get out there. There are law firms and other advocates who will work on a contingency fee basis, meaning you'll only pay them if they actually win the case and you get money. Now, we certainly do that for people. We can't do that in every case, so you have to kind of figure out if yours a situation where you could do that. But there's also other help. If you're on a long-term disability claim, some insurers are going to pay for you to get an advocate. They'll pay the advocate. And if all else fails, there are legal clinics across the country that can provide free help, although those are hard to access often. Okay. So what if you're denied again? So what that means is you do the reconsideration and then you put it all in, you get your letter in, you send in the new stuff, you get the reconsideration request form in, you request the thing. What happens if you're denied again? Well, you have actually 90 days, and now you have to appeal to the Social Security Tribunal of Canada, the General Division. This is a more formal stage of the appeals process, and it also moves outside of Service Canada. So now instead of dealing with Service Canada directly, you'll be dealing with the tribunal, the Social Security Tribunal, which is its own thing. It's separate from Service Canada and independent from them, although it still falls under the same government regulatory structure. They are separate and independent from one another, and there's no sharing of information. So the Social Security Tribunal has, I call them judges. They're technically called tribunal members, but the tribunal members are the judges that will hear your case. Most of them have legal training and background, and they will act as a judge on your case. And at the tribunal, the General Division is the first place you're at. Once you get there, the process is to have a hearing set up before one of these judges, and it's just like a mini trial like you would see on TV, where you go to a courtroom, you give your side of the story. If Service Canada is there, they can give their side. You can then give your evidence to the judge, and the judge will make a decision to approve or deny the case. That is, in a nutshell, how the hearings work. Most of the hearings can be in person, but a lot of them are done by Zoom, or they can even be done by telephone. And but that is your best chance to get your case approved, is at one of these tribunal hearings. Now, if you do things right, it's still possible after you have, let's say your reconsideration has been denied, it's still possible to have your case approved. You would appeal to the tribunal, but between the time of appealing, the tribunal accepting your appeal and you having an actual hearing with them, there is like a period of time there that can be several months, up to a year sometimes. Your case can still be approved within that period of time before it gets to the hearing. That's our goal with most cases, to try to get them approved before the hearing. And so just keep that in mind, that can happen. You're not locked into going to a hearing just because you've had to appeal to the tribunal. So let's look at some documents here. Now I'm going to share my screen. Just bear with me here. Okay, here we go. So this is, make sure I got the right one shared here. This is a sample initial denial letter. This is exactly what it looks like. And this is what yours will look like, because basically they're all the same. They just fill in the name here of you and your ID number, and that's it. They basically are all the same. This is what it will look like. So you'll see with this person, they say that they got your application on this date, and they say here, we cannot approve this application for disability benefits, shows the disability rules have not been met. That's what it'll say on yours, because it says it on all. It lays out the disability rules. Now, sometimes, like, the differences is if in this case they're saying because the person didn't meet, they'll see here, they say rule 1 is met, rule 2 and 3 are not met. So in this case, often they'll say rule 2 is met, but in this case they're saying you are under age 65, but you haven't met the minimum valid contributions, and you haven't proven that you have a serious and prolonged condition. So this is most often rules 1 and 2 will be met, and it's just rule 3 they're focused on. But rules 2 and 3 are not met here. That's because with this case, I'm not going to give you details because it's confidential, but with this person, there was an issue about, like, this was a late application, and there was some dispute over whether the disability started before they ran out of CPP coverage. Now, newsflash, this case, we were successful in winning this case before the hearing. So based on, this is just the initial denial letter for this person. And so there was a reconsideration done, and then it went to the tribunal, and we were successful with this case before it got to the tribunal hearing, but right before. And you will see here, they're just saying the information we received from your healthcare providers supported our decision. So it's very vague. They will say the same thing. You can see there's nothing specific about this person. They're just making general statements. And this is another thing that you will just see the same wording. Our records show you may be unable to return to your usual job. However, it does not show limitations that would prevent you from doing, like, they just throw that out in everything from some type of work more suitable to your limitations. Okay. So this is just the general wording. Then you'll see down below here, this is, again, all just the same. It's all, if you have any questions, call us here. If you disagree with the decision, you'll see here, they're saying within 90 days, you need to appeal. And to request the reconsideration, they're telling you different ways to do it. So you can request it online. I forgot to mention that. So you can request it online through your My Service Canada. So you can go in there and fill out the form and upload it. And, or you can mail it in. You can't really email, or I wouldn't try to fax it either. Most people don't fax nowadays, but I would not try to do that. You basically, the ideal way to do it would be go do it online. And you'll see it is signed down here by your medical adjudicator. I've deleted out this person's name, but you'll see this is a nurse, registered nurse, medical adjudicator. All right, so that's what an initial denial letter looks like. So this is when you would have submitted your application. This is unfortunately the letter that comes back and says you've been denied. Now you'll look at this. This decision came in November of 2023, and this person had submitted it in June. So July, August, September, October, November. So 5 months. That's a normal time period. That's actually pretty good. Now, this person then would have had to move on. So this person got their denial. Now they need to request their reconsideration. Again, what I recommend you do is fill out this form. This is the official request for reconsideration form. This is the one we use with clients. We recommend you use it as well. And it has instructions here. It says you have to submit it within 90 days. But really, there's not a lot to it here. You just fill in your information. Please select what you're doing. So you would just put disability. Where is it? Why am I not seeing it? Please select the applicable. Oh, right there. No, that's death benefit. Post-retirement. Did I get the wrong form? Why doesn't it say disability benefit there? Retirement pension, post-retirement death benefit for survivors. Huh. Maybe I picked up the wrong form here. That's strange. I just grabbed this one quickly before I came in here. Well, I'll make sure I post in the link. I'll make sure I give a direction of where to get the right form, but it looks exactly the same as this, but there would be a box that says CPP Disability. Just a second now. I'm going to go see if I can find it. Let's see. Yeah, here we are. Let's see if this is the right one. Yeah, okay. Yeah, I have the wrong form here. So let's get rid of that form. And Nope, that's the wrong form. All right, this is the form. Let me make sure you guys are seeing this. Yep, you are. So this is the right form. It's basically the same request for reconsideration of Canada Pan disability. So this is the right form. And again, you fill out your applicant information. You would just put the disability benefit here. Most people, it's not going to be a post-retirement disability. That's not going to apply for you unless you are age 60 and up. Now, the date on the decision letter you received. So for us, that date would have been 11/27/2023. So you would go here. Let me just move this over here. Oh, sorry. Sorry, folks. I'm making mistakes here. This is why live TV is not good. All right, let's try this again. Okay, we're back. All right, so you would just put your date of the denial letter in there. And it says important if you are late, is your request more than 90 days from receipt of the decision letter? If it is yes, then get legal help. The reasons you put here are extremely important. And if you just write reasons here, you're likely just going to set yourself up to not be, you may not know how to word it properly. It's not that someone's going to lie, but you just may not word it right. You may think this is the important thing to emphasize, and it may not be. So you have to be very careful. So hopefully you're not going to be in that situation. Then down here, I want Service Canada to review this decision using, it says information already submitted today, provided, information already submitted, new information that I will be, so right here. This is the third one that, because I want you to do this right away. You will not have had, I want you to do this so fast, you will not have had time to get other information. So don't wait at all. Just do this. Information already submitted and new information that I'll be providing as soon as I get it. Then they want to know like the type of information or date of the upcoming appointment. So if you know you're going to be visiting your doctor for the purpose of getting them to maybe do something else, you could put the date in here as if you know it. You could say upcoming appointment with doctor. You probably won't have the reports. So you just put whatever in here you think you're going to get. At the very least, put new information from family doctor, document enclosed, no. And when will you send it? Just put like whatever the 90-day deadline is, put that in here, something like that. Reasons you want the reconsideration. Again, don't fret too much at this form. You can always supplement more reasons. So you could say that you disagree with the decision and believe that you do meet the criteria for a severe and prolonged disability and that you meet the criteria for contributions, whatever it is, whatever the reasons they denied it, just say that you disagree and think that you do meet those conditions and that more information will be provided, something like that. You don't have to go into a long explanation here. The whole purpose is just get this form in as fast as possible. Here's your whole privacy statement. This is just talking about them protecting your information and all that. Don't worry about this part too much. Just agree to it, sign, and send it in. These parts aren't really needed. This is only if you are unable to sign a signature. You don't need that for most people. And yeah, so again, these sections are only if you have someone, because you are unable to do this on your own, you're having someone else fill it in, then that you would fill these parts in, but most people are not going to have to do that. Okay, and then here's the offices of where you would send it. But again, you could upload this to right onto your online account, which would be the best way to do it. But otherwise, this is where you send it. You don't take it to your local Service Canada office. There's certain offices here where you would mail this in for your, like, for example, in Nova Scotia and Prince Edward Island, it's the same one. Alberta and Northwest Territories, it's the same one. In Edmonton, etc. All right. Last but not least, let's look at the denial letter. So let's say you've submitted your reconsideration. This is what can come back. This is a denial. It says This is on the same case as this initial letter here. So it's this. I'm just following it through. And keep in mind, this person got approved later on. So this letter is about your request dated February 19th. So how quickly did this person get the request in? They got this letter. Okay, they waited almost right to the bottom line here. Yeah. So that was November, December, yeah. So they waited till the last minute to put the request in. This is before they hired us. So they did not follow what I would recommend. They waited to the last minute. They were days away from missing the deadline. Don't do that. And again, you can see this is just general. They're just giving general statements here on why this is being denied. It's a little different than before. It defines severe and it defines prolonged. And you will see here, now they're saying they do meet rules 1 and 2. Okay. So now they're changing their tune so that now they're saying it's only rule 3. Whereas before, if you remember, they were saying it was, you didn't meet rules 2 and 3. But 3 really means that you're not having a severe and prolonged disability. That's the most common reason that they're going to say. But it's just a general statement. You can see there's nothing specific here. It doesn't mention anything related to you. This is a general statement that everyone will get. So it's not that helpful. Same kind of statement that while you can't do your own job, you might be able to do other jobs. And then it's the same thing. They tell you here you got 90 days to appeal to the Social Security Tribunal. I'll cover how to do that in a different video, but that is basically what you would do from here. And it's a different medical adjudicator. There's some definitions here attached. So explaining what substantially gainful is. The key thing to know is like the Social Security Tribunal has here is the address and different information. And there is a notice of appeal form that you want to use when sending this in. Right, I'm going to stop my screen share there. And we'll move on now to doing some questions. Now, before we jump into questions, I will say that if you, let's just go back there, actually back to our, let me go back to my slides here for a second. So just some final thoughts for you guys. The reconsideration is the best chance you have to try to get this thing approved early on. Get information in. Oftentimes where you can be successful on a reconsideration is if you didn't give a lot of information, like you didn't already give the full family doctor's file. That's one way to do better with the reconsideration. The key thing is going to be, though, to just make sure you meet the deadlines. And a lot of times you won't really know what information you need to give them because they give you they don't really explain why it was actually denied. They're just making a general statement that you don't meet the criteria. Now, it's not the end. My recommendation is just to get through the reconsideration as fast as you can. While it is a good chance to win, I really think your better chance is when you get to the tribunal and in the period between when you file your notice of appeal with the tribunal to the hearing. That is actually your best chance to get approved for most cases. Whereas I do find, like with Service Canada, they are very quick to just look it over and deny a case, especially if you don't have new information to get them. It's hard to get the new information to them in time because you only have the 90 days. Now, they will give you more than 90 days, but they will, if after a month or so after that, they will probably make a decision just based on whatever information they have. Now, if you need help, certainly get in touch with us for a free consultation or go ahead and download my book. The links are in the description down below. My book is on CPP Disability. It includes a whole chapter in there on how to do appeals, including reconsiderations. You can check out our website as well. So let's move on to the live Q&A. I do see we have some questions already in here, so I'm going to go on with that. Let's look at this first question. It says, David, does CPP Disability go with doctor that wrote forms or what I wrote in forms? So that's a good question. They will consider both. Certainly the doctor's information is very important because to win a case like this, you do need medical information that supports that you have a disability that is severe and prolonged. So what they're looking for from doctors is a confirmation of your diagnosis, of the type of symptoms you have. And if you recall last week's videos, we looked at the medical report. You can go back and check out that episode. when the doctor fills out the medical report, there's certain sections of that report that talk about, how long is this expected to last? Is it expected to get better or worse? See, if the doctor says last a long time, not expected to get better, these are things that would indicate it's a prolonged. And it will also ask if there's what the limitations are. So if the doctor lists limitations, that helps, because those limitations can then be applied to how they would prevent you from working. So the doctor's report is quite important. Certainly what you say is also important, but not as important as what the doctor is saying, quite honestly, because ultimately there needs to be a medical diagnosis and a description of medical limitations arising from the diagnosis that would justify why you can't do a job. Very good question. Okay, another one from Robert. Hi, Robert. Good to see you back here again. What if necessary contributions were the result of credit splitting? Okay, so let's start with what credit splitting is. So if you are in a common law or marriage, and during the course of that marriage, one or both of the spouses contributes to CPP Disability, then upon a separation or a divorce, what will happen is Service Canada the CPP Disability Administration, they will basically combine all of the CPP contributions from both spouses during that time and then divide it by 2 and give half to each. So that's what will happen. And they're treated the same as any other contributions. So some people, they can get valid contributions through credit splitting, quite honestly. So credit splitting is completely fine. It will only apply to the years where you cohabitated with the other person, but it can increase or decrease your contributions, because it will increase the contributions from the lower contributing spouse, and the higher contributing spouse will decrease. The lower contributing spouse's contributions will increase, and but it won't matter. Like, they still will count towards being approved, like having enough valid contributions. The other way you can get valid contributions through credit splitting for years you may not have worked. You can also get contribution credits for years you were out of the workforce raising a child under the age of 7 if you were the primary caregiver. That's another way you can get credit for years of contributions where you didn't actually contribute or work. So there are some exceptions in there. Another one from Yusa. No need to apologize. This is a very common question. Why can't you sue the Workers' Compensation Board? That is a very good question. And I'm going to take a drink of water before I get into this one. Okay. So workers' compensation, let's just start from the beginning. Workers' compensation is set up in each province, and there's a federal workers' compensation as well. It was brought in through something called the Meredith Principles back in the early turn of the century. I'm going to get the date wrong when exactly it happened, but it was earlier in the early 1900s is when there was a change. A policy decision was made to move away from a system where employees would sue the employer for workplace injuries, and to move towards a system where employees would get compensation for work injuries regardless of who was at fault. So basically what happened was there was a policy change in Canada where all the provinces and the federal government decided to make it illegal to sue employers, and in exchange, they required each province to set up a workers' compensation program that would be funded by employers primarily, and that would pay benefits to injured workers regardless of who was at fault for the injury. The problem under the old system is, if you were to have under the old system, you could sue the employer, but when you're suing an employer, you have to prove that their negligence caused your injury. That's not always easy to prove, and sometimes it wasn't the lawyer's negligence. Maybe it was your negligence or negligence of another employee, or maybe it was just an accident and nobody was really at fault. So that was the problem. It was difficult and expensive for for people to try to prove that the employer was negligent and caused the injury. Now, in some cases, you can prove that. It's not impossible to do. They decided to move away from that and go to a system where you no longer have to prove anyone was at fault. It's irrelevant who was at fault, but you do now have this process of workers' compensation where you still have to prove that you were injured, that you were at work, and so forth. It's debatable which process would be better. Certainly, when you're able to sue directly, you have a lot more power to control the process. So I'm not necessarily saying that workers' comp was a good thing, but from a policy point of view, it would seem that it would be a better system because people don't have to prove fault. There's always going to be money there. But in reality, when it plays itself out, becomes a very complex system that is very hard to navigate. So the question's still out there whether it's a more positive system rather than just allowing employees to sue. But that's the reason. That's the reason. It was just a decision made long ago that they were going to take away the rights of people to sue, and in exchange for giving up those rights, people would have access to a no-fault system where they can file a claim and be compensated regardless of who was at fault for the injury. This one says Service Canada. Okay, let's see here. I have the necessary contributions after the splitting was done. Then in theory, I should be fine. Yes. Yes. Yeah. Splitting is usually not going to take you out of having enough credits to qualify. But that I'm not 100% sure on. But if there's splitting going on, they will reassess you after the splitting happens. I mostly see it from the point of view of people who don't have enough. So I usually see it from the point of view where someone comes to us and says, I've been out of the workforce. It's often a woman. I've been out of the workforce in the marriage and my disability happened here. And we're like, well, unfortunately, you will not be successful because you did not have recent contributions to when your disability onset. But they're like, oh, well, but I'm separated. I'll be like, oh, wait a minute now, apply for credit splitting. And now if the disability started during your cohabitation and they will then split the credits and you now will have credits for that period of time. And it may be enough for contributing years to qualify you. All right, great question. I'm not sure if anyone on the call here or then any of the people watching have ever done a reconsideration. I don't know if you have any tips or advice for anyone. The longer I've done them, the more I have shifted to say, just get them over as fast as possible. Because in my experience, we have better success getting people approved at the Social Security Tribunal stage, honestly. So when we're representing someone, I now tell clients, look, we are going to, instead of pulling out all the stops to try to win this reconsideration, we're going to get the reconsideration in. We'll put as much information as we can get in, but we're really going to just focus on getting past this as fast as possible so that we can build the case at the tribunal and hopefully get it approved before it ever gets to the tribunal. The problem we have is with reconsideration, you don't have all the information. So as a lawyer, when I'm representing someone and they come to me, they've done their own application, they've been denied, I have no information. I don't have a copy. I don't have a copy of what they sent in. They don't usually have a copy of anything. So they don't have anything that they sent in. I don't know what their doctor said. I don't have any records. So what we used to do would be we would request the full file from Service Canada. We'd get the doctor's file. That takes a tremendous amount of time, usually well beyond the 90 days. And then we would end up getting a denial anyway. So our new process is that if someone hires us, we don't request the file from Service Canada, because if you request the file from Service Canada, they will take forever to get it to you. Once your reconsideration is denied and you're going to the tribunal, and you file your notice of appeal to the tribunal, Service Canada provides, because of the rules, they have to provide the copy of the file almost like within a week or two. So you get it immediately. So what I learned is that, yeah, we can try to get the copy. We're going to get a copy of the file anyway when we do the appeal to the tribunal. We'll get it immediately. Or I can request it during the reconsideration and wait an ungodly amount of time to receive it, only to be denied, and then just to get it again. It made no sense. It was prolonging people's cases to try to build everything up at the reconsideration stage, given the time constraints that you have. A lot of people also hire us like when they're getting near the end of they don't have the full 90 days. They're coming to us with like a month left or something. And so I've moved away from trying to do a comprehensive, do your best shot at the reconsideration stage and just get past it. I just tell clients, let's just get past it. If you're worried about I ask my client, what is your goal? Like to be as approved as quickly as possible. If that is the answer, then let's just get past this reconsideration step and get to the tribunal step. That way we can build up the better information, get the stuff from Service Canada, get all the other records in, get it all in. And then what happens at the tribunal stage is, at the tribunal stage from Service Canada's point of view, they will transfer their case over to, they have designated people, paralegals usually, who are responsible for the cases at the tribunal. So Service Canada hands off the whole thing over to these specialized people. Those are the people I like dealing with because they're busy. They've got a bunch of things. They have to write all the legal submissions and things into the tribunal. So they have lots of work to do. They're super busy. I like to hand them, with a bow and ribbon on top, I like to hand them a case that is so easy for them to approve that they will be like, okay, yes, let's approve this, because they're super busy. They can easily approve it and move on to deal with all these other more difficult, these other ones, right? So I like to hand it to them on a silver platter. When you do that, they will approve the case and it does not have to go through to the tribunal. That is the goal. That I have found that it is almost impossible to do that same kind of approach when dealing with the reconsideration people, because you've seen the kind of letters they write. They just like deny. They don't give any reasons. They're just trying to move things along. They're being judged on how quickly they process things and get it off their plate. So they will approve cases in some situations, but for me, because of how many of these I've done now, I've realized that it's better served for my clients to get them past that stage as fast as possible and get to the tribunal stage. That's for us. I'm not saying that's going to be the best thing for you representing yourself, but that is the best thing for us to get people approved more quickly. All right. If an older version of CPP Disability form has been used, can you update a form with additional info? I wouldn't worry too much if you've used an old form by mistake. You certainly can. You can always send in supplemental information to CPP Disability, but I wouldn't be too concerned if you used an old version of a form. They'll let you know if they need updated information. But yeah, you can always supplement and provide new information. That's again why I tell people just get your reconsideration in and just keep supplementing new information. Same thing with your application. I tell people get your application in right away. Do the bare bones, get it in. Then it's going to take them 6 months to make a decision. So get the application in. If you want to make it better, then you can send more things and just keep supplementing it. And that's completely fine. But the sooner you get your application in, the better, because it starts the clock ticking on more possible. You will get every month you delay putting in your application is a month you lose in past benefits that you otherwise would get. So you want to get the application in as soon as you can. And then you can supplement your application with more information. If you've used the wrong form, certainly you could send in a new form, but I wouldn't send in a whole new application just because if you use a different version of the application form, I would not worry about that. They'll tell you if they think if the form is just not usable anymore, they'll tell you, but often it's not going to be a problem. All right. Anything else, folks? Got a little bit more time here. Let me double check while you're waiting for more questions. I'm just going to check a quick little Google here. I'm dying to do an update on the Canada Disability Benefit. I'm kind of waiting for new information to drop. Like, new information should be dropping soon because this benefit starts this summer. Yeah. Don't see a ton of new information on the old Google, but let's see. I could possibly do the update. Friday is obviously a holiday, so we won't be doing it. Monday's a holiday. Maybe what I'll do is Thursday is our call-in show. So maybe before the call-in show, I will do an update on the Canada Disability Benefit if people are interested in that. Obviously, people are generally interested because our live stream where I covered that a few weeks ago, that was one of our highest viewed videos. So people are interested in knowing what is going on. So I think what I'll do is do an update on Thursday on the Canada Disability Benefit, just review everything that I did the last time, how it works, and what to expect when what we're waiting on. Like, there's certain things we're waiting on, what people can be doing now to get ready so that when the new stuff drops, you'll be able to just move quickly. You can start being approved. You can be approved as of June 2025 for the period of time between July 2025 and June. Like, you'll be approved for a 1-year period, July 2025 to June 2026. That would be the period that you get approved for. And you could be approved for up to $200 a month, less if you are above certain income thresholds, and zero if you are way, way above the income thresholds. Okay. You know it. I'm going to plug my book, CP Beginner's Guide to CPP Disability. This is a book I wrote. We've given out, I'll say, thousands of copies. If we go back to the first edition, definitely, maybe well over 10,000 copies of this thing have been sent out. We send this out to everybody. So you don't have to pay for this book. We send this out for free. You can get a copy by down in the description of this video. There will be a link where you can order a PDF copy of this book. So just an electronic copy will be emailed to you. You can also, once you do that, you'll have the opportunity to order directly from us a print copy of the book, which we would send you. Where is it? Thought I had a copy here handy, but I don't. I guess it's behind me there. But we do have print copies that I can send you. It's a paperback, along with other, depending on where you're at. So if you fill out that form, it'll be asking you what stage of the process you're at. If you're at the application, if you're doing your reconsideration, and we put in other documents depending on what stage you're at. So you can do that. And that's pretty much it. Appreciate y'all for joining me this week. I'm just going to call it a day. Go have some supper, get ready for some things I'm doing here this evening. Hope to see y'all back here tomorrow. We're going to be talking about long-term disability. We're going through tomorrow. I'm going to be starting the process where I go through my book. This book is my book on long-term disability. We're going to now be going through, you'll see this book. I don't know if you can read it well, but Proven Strategies to Avoid the 11 Mistakes. So over the next 11 weeks, we're going to go through all 11 mistakes. So the mistake tomorrow we're going to be dealing with is mistake number 1, using the bare minimum approach for your application and appeals. There you go. That's going to be our first mistake we deal with tomorrow. And then on Wednesday, I'll be talking about employment law topics. Not 100% sure what it is, but if you check the email that goes out, if you're on our email list, you would have been notified. Otherwise, you can just watch on our YouTube channel and you will see it pop up. Other than that, I do wish you all the best. Take care, folks.